My name is Paul Sullivan. I'm a judge of the 17th Circuit Court in Kent County, and I also have the honor and distinction and privilege of serving as longtime chair of the Michigan Trial Court Performance Measures Committee. I say it's an honor and a privilege for many reasons. Number one, I'm really pleased that the members of our committee work as hard and as diligently as they do. And without your input, which is very valuable, we would not be doing this. The other reason I'm particularly encouraged and honored to be chair of this committee is that in the recommendations we have made to the Chief Justice and to the other justices of the Supreme Court, it has been my experience that whether they necessarily agree with our recommendations or not, by and large they accept them. And I think they accept them recognizing that each of us comes from our own unique perspective as a trial court judge or administrator. There was one area, however, where the court and the Chief Justice did not accept our recommendation, and that was in the area of public satisfaction surveys. So after the latest round of surveys, we as a committee revisited how often these surveys should be done. And we recommended to the Chief Justice that while the surveys continue, the public satisfaction surveys, that we do them biannually, every 2 years rather than annually. And in one of the very rare occasions where the Chief Justice did not agree, he said, no, we're going to do them annually. Now, I say that because I respect his position and I respect our position at the time, and we, of course, accept his position. But in hindsight, I have to say that I believe he was 100% correct. These surveys, as we all know, these public satisfaction surveys have been extremely positive. The Chief Justice of the Supreme Court has taken that information and has used it to go out to the media, go out to the public at large, go to the executive branch, the governor, go to the legislative branch, and basically tout these survey results as evidence of what a good job our trial courts are doing here in the state of Michigan.
So performance measures are something that we've always used internally to help us determine if the services we're providing need to be expanded, if they need to be discontinued, if they need to be improved. It's something that we've always looked at in terms of we have a finite number of resources and we have to use them efficiently to do our number one job, which is dispensing justice. So the services were effective and we're dispensing justice and we saved a lot of public money. And that's the number one goal, obviously, is that we have to dispense justice, but how do we do that with public money that's entrusted to us? So if you take the performance measures, and we're always internally looking at the better way we can give those services, what another tool that has become available to us in the last few years has been the public satisfaction survey, which has been incredibly helpful because we're not expecting people to say, well, were you happy with the decision? Because that's not really what that's about, is were you listened to? Were you directed appropriately? Were your questions answered? Do you feel that you were welcomed into the courthouse? And that's really important because the only people that can tell us whether or not we're providing the appropriate services is the users themselves. So the satisfaction survey is an incredibly important tool, and it's one that I think all the courts should actually want to embrace because it will help them eventually with, again, being better able to spend their public money and having better relations and communications with the actual users of the court.
The courts right this week and next week, and this is middle September, engaged in the public satisfaction survey. We value that survey because it tells us how we're doing. Now those are common buzzwords, but in fact, if we find that we are deficient in certain areas, we need to know that. And we're not going to know it if someone doesn't tell us. Public satisfaction survey gives us that information and allows us to make the changes necessary to see to it that we serve the litigants and the attorneys that appear before this court.
So the reason I favor these surveys, even though they can be worrisome and time-consuming, is that it helps me avoid mistakes. I learned as a practitioner, a lawyer in the trial courts, that I wanted to know ahead of time. I wanted to discover where the potholes were in my litigation road. I didn't want to drive into one of those potholes that I could have seen if I'd only taken the time to find out about the route. So I encourage you to use these surveys to your own best advantage, and good luck.
And when results are positive, and they often are, they allow us to communicate these positive results to our court family, to our funding units, and to the public at large. It's good PR. Maybe we need additional judgeships, perhaps additional funding, perhaps additional staff or additional programming. We may or may not get these things that we're asking for, but when you have performance measures and we measure what we're doing and they don't come out the way we would prefer to see them come out, sometimes it's not because we're not working hard, it's not because we're not doing a good job, the judges and the court staff and so forth, but it's because we simply don't have the resources we need. And we can use these performance measurements to help us to try to secure what we do need to do a better job.
As we moved into the development of a treatment court and looking at the science and the data and looking at the needs to provide better services by applying for grants both at the state and federal level, we realized how important performance measures are, and it gave us the information we needed to be able to continue not only with the treatment courts in family, but also expanding those courts to swift and sure, felony court, mental health court, and sobriety court. So I think that from our perspective in Cass County, treatment courts have been a catalyst for change, and the measurements have assisted us in developing that catalyst and measuring it.
When you look at a recidivism rate, you were able to tell whether they have stopped. So we look at 4 years out from your program, and in Michigan, if you're a problem-solving court judge, you should be quite happy with the results. The recidivism rate in district courts on average is 11%. For people who did not go through the problem-solving court program, during the same time period, the recidivism rate is 19%, almost double. So it shows that what we are doing is working. We're teaching people how to act in recovery. We're teaching people how to manage their mental illness. And that's what you're using the recidivism rate for, to determine is your program working at its optimal level. I think that the general public and our elected officials still treat problem-solving courts as something special, something unique, not necessarily an essential part of the criminal justice system. We as problem-solving court judges need to change that. We want problem-solving courts to be a fundamental part of the criminal justice system, business as usual. When we talk to our funding unit in Taylor this year, we'll be telling them that our recidivism rate for people 4 years after admission to the program is 9%. The recidivism rate for those people who should have gone through our program is 24%, almost 3 times as much. What it means when I look at a public official is I'm able to say, these people who committed crimes in our community and who went through our program, 91% of them no longer commit those crimes. They have stopped. It's a very compelling number. It is a story that all of us as problem-solving court judges should be sharing with our funding units, with the general public. The best way to do that is through the use of your performance measures.